So now turning to Bence, I will start asking him some questions. And the first one is, Bence, how important is a product's trade dress when it comes to consumers choosing that product over others in the market? What do you think about it?
Thank you for the question, Rafaela. And also, I'd like to take the opportunity to thank Dannemann Siemsen for the invitation to this webinar. It's a pleasure to be here, and also pleasure to speak with everyone on this webinar. I myself am based in London. I've been with the Mars company for about 9 years now, and mostly working in the chocolate and confectionery space. So I have global responsibility for trademark work, including brand enforcement. And as you can imagine, we encounter quite a few lookalike products or trade dress infringements globally. But my view is predominantly based on this sector and category of food and chocolate and confectionery that we work with. So bear in mind, when I'm answering these questions, I have this sector in mind first and foremost. So the importance of trade dress for consumers, I think it's absolutely vital. It's essentially there's scientific data that shows that it is actually the basis for trust and also for the purchasing decision of the consumer. And when I say science, what I mean actually is behavioral science. There's many studies published in this area, but I think most recently in the UK, there was a study commissioned by Stops, the IP firm, that actually showed how important psychology is and how consumers behave specifically in a supermarket environment. And according to that data, it is actually the trade dress is much more important than, for example, the name of the product, the brand name. The data actually gives 3 key findings. One is if the consumer is in the store, they rely on what we call system 1 thinking. So it means that decisions are made outside conscious awareness effectively. And you will get different results if you assess the consumer behavior directly compared to when you ask the consumer, why did you purchase that product? So it's that nuance that they will give a different answer compared to what actually drives them to purchase the product. So that was the first key finding. The second key finding is basically how consumers perceive color, and basically color and shape are those elements of the product that should be really given more weight, even in IP, because those are the decisive characteristics of the product that actually drive mental availability and purchase. So those mental shortcuts that we talk about in trademark law and IP law, they're triggered by much more by colors and color combinations than they are triggered by brand names. And then lastly, the third key finding of this psychology of lookalikes is that the consumer perception of an actual lookalike product improves with similarity. So basically, a product is basically thought of as having better characteristics, better quality if it is reminiscent of a famous trade dress, for example. So it has this positive connotation, which is what these lookalike producers or trade dress infringers try to exploit, essentially. So, I mean, the conclusion of all of that is pretty much that the consumer will remember the well-known trade dress, and it will trigger those mental shortcuts and positive associations that actually leads to buying the product. So it's super important and also a good reminder for brand owners around the world to actually create inherently distinctive packaging and branding and then enforce against imitations worldwide. Because if you don't do that, then your branding effectively dilutes over time.
My next question would be, do you think that competitors, that they have parameters and standards when it comes to copying the trade dress of a market leading product? How they usually behave?
Thank you, Rafaela. So I think it's a great question. It always depends on the sector and industry of where these players would compete against one another. But based on also the answers to the previous question and based on science, colors are very often copied alongside logos or script styles, whereas brand names are copied less so. And however, the brand name often starts with the same letter to give that additional association. But I think colors and color combinations, distinctive features are copied more often because also I think they can get away with it if they don't copy the brand name. And then I think there are several claims that the trade dress infringers would make, or they would sort of defend their behavior in certain ways. And one of the claims is that they are effectively benchmarking against the entire competitive set, the entire category, and not just the market leader. Whether it's true or not, you would have to sort of decide yourself based on the facts of the case, but that's what they often say. But what we see and what happens often is that even if they say that, they would actually single out the market leader and copy their trade dress. So what they also say often is that they are using what they call category cues, or colors that define the category rather than the brand. And basically, they also say that due to the fact that these are category cues, they are not ownable and they're not distinctive in the category, so they can use it. Again, often this is not true, but often it is claimed. And then they also claim, I think, usually two more things. One is that there's no confusion, so that the consumer is not confused effectively. So the consumer is not stupid. They can see that this is a different brand name, different product altogether. So that's what they would also say. And not only that, that's not confusing, but also that is actually helping the consumer to find a cheaper alternative or of a product of the same quality. But as you can see and hear, I'm a little bit kind of skeptical of these claims. And effectively, I think personally that the goal is to achieve what we call change of economic behavior on the side of the consumer through the image transfer. So these cases are often image transfer cases where image of a famous brand is transferred to the other product, and the economic behaviors change so that the consumer does not buy the branded product, but they buy the lookalike product. So that's the sort of goal of the competitive behavior often. And what would also happen is that they would test the waters. So they would go out with a trade dress, launch a product, a little bit similar. And if they are not challenged, then over time, they tend to kind of creep closer to the original one if they remain unchallenged. And also, I think obviously in some countries, brand owners have it easier than in others. So I think they know that, and they monitor the IP framework and case law so that they can effectively go as far as they are able to without infringing. And yeah, I think all in all, what I think is they are essentially, as I said, achieving a change of economic behavior through manipulation of consumers, of their system one thinking, the more intuitive thinking, into buying products that they think have the same quality, whereas often this is not the case.
Perfect. What do you think that IP owners and their attorneys, lawyers should consider to protect and enforce trade dress against other imitations or infringements in the market?
Yeah, no, I think this is interesting and also based on the jurisdiction, and I would be really curious to hear Mauro later speak about Brazil as to what is possible in Brazil and what is, on to the contrary, what is difficult in Brazil. Globally, I think what is proving to be more and more common and effective is to actually try and somehow protect the overall impression of the packaging or branding, not necessarily simply individual elements of the packaging separately, but protect it all together, maybe as a front of packaging, trademark registration, potentially, and then build recognition of this packaging, of the trade dress over time through marketing campaigns that hero these assets and the front of pack. And then I think for enforcement, you mentioned, Rafaela, in the introduction, that you can rely on several different, IP regimes, trademark infringement. Within trademark infringement, you have likelihood of confusion, and also unfair advantage as well. Others as well, but those are most common, I think. And then you've got copyright infringement, obviously, design, unfair competition, very commonly. Sometimes people would also mention consumer protection laws or misleading advertising, things like that, but it's less common. And depending on where you are in the world, you need to consider these, but most commonly unfair competition, I think, where available, and where not, then as aspects of trademark infringement where you have the right protection that I was talking about, and then the recognition in that packaging. And then in terms of, obviously, you have to think about what can I prove? Can I prove confusion? Can I prove dilution? Is it harming the consumer more? Is it harming the brand owner more? And then if yes, then how can I prove that, right? I think in a more difficult jurisdiction, I think likelihood of confusion will be quite hard to prove. For example, in where I'm from in Europe, you have unfair advantage, which if you can't rely on unfair competition in some jurisdictions, you go with the unfair advantage claim, which doesn't require you to prove confusion, but it requires you to prove that there's a link in the consumer's mind to the trademark with reputation, and there's also a transfer of image happening, a change of economic behavior. We talked about this before, and then there's an advantage as a result, an advantage that the lookalike producer would gain by this. And really, again, I would be curious to hear later if it is possible to rely on this in Brazil without having to prove confusion. I think what is important to note is overall, imitations not only exploit the basic function of a trademark, which is the indication of origin, but also they tend to exploit other functions of the trademark, such as advertising function, quality function. And I think that kind of argumentation helps convince judges that actually you have to look at more than simply looking at confusion in a case like this.
Now, in your experience, what should be taken into account to increase the chances of success in a court action or in a dispute involving trade dress infringement? And what do the courts take into account when deciding these cases?
I think you see a lot of different ways courts would look at lookalikes, and depending on where you are in the world, it could be brand owner friendly, for example, like in Germany, or much less brand owner friendly, like the UK. And what I think should be taken into account is, as I said at the beginning, for example, behavioral science should be taken into account. I think, yes, judges are experts of the IP law and trademark disputes, but are they experts of behavior science? Most of them are not. So how consumers act in store and what influences their decision is, you can't really assume one way or the other. It's a lot of that is scientific. And then one other thing that needs to be just taken into account much more than I think it is in most jurisdictions is the actual similarities in the overall impression and the colors and color combinations, whereas I think less emphasis needs to be on words, on pack and brand names. And then lastly, to my point earlier, which is essentially that not only confusion or likelihood of confusion infringes, that there is much more to an infringement than simply likelihood of confusion. I think dilution also is an infringement, or should be, and that's going back to what I said about the functions of the trademarks and how those functions are infringed separately and cause consumer effectively to behave differently. Yeah, so that would be my answer to that.